Mr. Reagan, Ms. Coyle, can you guys hear me?
I can, Judge. Good
I
morning.
can.
Excellent. Good morning. We're going to start with Mr. Moses.
Okay.
Mr. Moses, can you hear me?
Yes, sir.
All right. This is State of Michigan versus Larry Moses. Case 24058766601. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Can I have appearances, please?
Good morning, Your Honor, and Mr. Reagan. Lisa Coyle appearing on behalf of the people.
Ms. Coyle, good morning. Judge Williams, good morning. May it please the court, Philip Reagan on behalf of Mr. Larry Moses, who appears to be known for purposes of bond redetermination.
All right. Good morning, Mr. Moses. Today is the date set for the bond redetermination hearing. Bond is set intentionally unaffordable as to this matter. Mr. Reagan as to bond.
Judge, I'm going to be brief. We're just asking for some type of nominal, some type of money bond. Judge, Mr. Moses has a current pending case in Macomb County. Bond is $1 million on that case. We're just asking for some type of nominal bond. Now, this was a reissued case here, Judge. This malicious destruction of property and R&O and escape. We're just asking for some type of nominal bond in this matter, Judge.
All right, Ms. Coyle.
Yes, Your Honor, that is correct. This is a reissued case in which the officer failed to appear at the original preliminary exam. But I do note that the case that's pending in the Warren District Court is scheduled for exam on August 26th. That $1 million bond was lowered to $50,000 cash surety with a tether by Judge Shimura. That case is an AWIM carjacking, felon in possession, felony firearm, I would assume, with the felony in possession. He also has, it looks like he was on HIDA probation to Judge Edwards. He has a violation of probation. There were, I think, for the lien, looks like maybe a remand for that. I'm not sure. He also has a pending HIDA that he was for RCSP motor vehicle, fleeing elude third. That's under HIDA status as well. That's pending in the Third Circuit Court. He also has a prior UDA out of, which is not, it does not appear to be HIDA. That's out of the Sixth Circuit Court. That was a August of 23 conviction, which he got jail time for, it appears. Your Honor, the people are requesting a cash surety bond. It was set at $50,000 with a tether, so we are asking for that bond to remain the same with the tether based on his lengthy record. Do not know what's going to happen on the AWIM case, so we have to look at this case in its own. Here there was outstanding warrants for this defendant. There were officers tried to stop him. He ran from the officers. He had to be tasered. He slipped out of his handcuffs. He pulled the paneling off of the door, rolled the window down, and exited the scout car and ran and had to be tasered. Eventually got caught lying down in the growth. So, Your Honor, he is a flight risk as well as a danger to the community. It appears he may have that violation as well as he's on HIDA status in Third Circuit Court. So I'm asking for more than a nominal bond in case that case involves allegedly firing several shots at a complainant about a dirt bike. Guns were recovered after a search warrant on his house. So he does pose to be a danger. This is an escape lawful custody. So I'm asking for that to remain the same.
One moment. All right, I've had a chance to review the information. And these are very, very serious and disturbing allegations. The fact of the matter is, we've been here before. We've had the case, and I don't understand how, with this set of facts, you can't get officers to show up for, subpoena and examination. That being said, I am going to issue a nominal bond as the defendant is in custody on more than one matter and in more than one jurisdiction. Bond is going to be set at $1,000, 10% with a GPS tether house arrest. The next date is going to be September. Is this right? Ms. Biles, I got the 18th for a PCC here of September. 1 second.
Yes, it's September 18th.
That can't be right unless somebody changed it. Can we call Judge Sabri's courtroom and get an earlier date? I have to change the date then. Can you put it for what's the day is the 23rd? Can you set it for August 30th for the PCC? I'm not gonna change the exam date.
They might change it.
Yep. So Mr. Moses, your next date is gonna be wait a minute. I wonder if this was set because of McConico.
Oh.
We still had to do it within the statutory time, though, Judge.
Yeah, that's true. Yep, we're setting it for August 30th,
Great, thank you.
2024 for a probable cause conference. McCollum's just gonna have to get it together. All right, that concludes this hearing. You're all set, Mr. Moses.
All right, sir.
All right. The young lady in Division 1, 6th floor, can you tell me your name? The person in Division 1, miss, can you tell me your name? Yep. Oh, you're still, there we go. Try it now.
Mariah Bush.
All right, this is State of Michigan versus Mariah Bush, case 24058713101. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable in this matter. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Your Honor, Philip Reagan on behalf of Mariah Bush, who is here for bond redetermination. Your Honor.
All right, thank you both. Miss, and good morning, Miss Bush. Mr. Reagan has the bond.
Judge, Miss Bush's bond was set a $10,000 cash restricted bond, no alcohol, no illegal substances, GPS testing. Your Honor, I would point out that my client, doesn't have any assaultive history. It's my understanding.
Excuse me, Judge.
Hey, Mr. Reagan, I'm sorry. There's something wrong with your background. There's just a lot of noise back there and it's not coming through.
It's quiet over on this end, Judge.
Well, let me try to mute Miss Bush. That might help. I'm sorry, Mr. Reagan. You can continue.
You're fine, Judge. Judge, I would point out that I do know the 2018 fraud case. My client completed probation, Judge. I'm trying, I think there might be a previous drinking case. Now, I would point out in this case, Judge, I don't believe the blood alcohol level, there are no test results that have come back yet on this case. She is not working at the present time, Judge. She does have one son. I'm actually requesting, Judge, a personal bond. I think that the court could use a less intrusive measure than actually a cash bond to ensure with no driving, no alcohol, whatever other conditions the court wanted to impose. But obviously, Judge, I am asking, and again, this is a bond hearing, Judge. We're not, to try our facts to determine whether something happened or not. We're just asking the court to consider bond in this particular case. And I think the court could do a personal bond with whatever conditions the court wanted to ensure that Ms. Bush did not drink, does not drive. So I'm asking the court for that at this time, Judge.
All right, thank you, Mr. Reagan. Ms. Coyle as the bond.
Your Honor, I do see 2023 out of Fraser District Court, 39B. She pled guilty to operating while impaired. Her high BAC was dismissed. She received a probationary sentence. Also, out of the 47th District Court, which is Farmington, there's a bench warrant for a failure to appear on a disturbing the peace probation violation. And the lien says no bond. She had pled guilty under a FIDA status. She received probation. This case occurred at about 4:05 in the morning. As the court can see, she and her infant child were in the car. She crashed into a guardrail. She refused to provide her name to the officers. She refused to perform field sobriety tests. She cursed at the officers. She resisted cuffing. She bit the officer's arm, broke the skin. That's why she's charged with the R&O injury. This is a felony. She then had to force her down to the ground to cuff her. They ran the lien on her license plate. It was a false license plate. Your Honor, based on all these things, the blood results are pending, likely will show that she was operating over the legal limit of 0.08. Your Honor, based on all these facts that she has a failure to appear right now, she has a prior OWI. She made the mistake of getting behind the wheel of a car when she was drinking. Not only that, she placed her infant in that car, and then she did crash that vehicle. So she is a danger to the community because she put her own child at risk and caused an accident, which could have been way more detrimental. Your Honor, I'm asking for that cash bond to remain in place, a tether, as well as the alcohol tether, because obviously she knows she's not supposed to drink and drive and she can't control herself. And so in this way, we're asking for the cash bond because she cannot use common sense and not to get behind the wheel of the car, especially with her child in the car, and drive a vehicle.
1 second. All right, I've had a chance to review the investigator's report as well as figuring out what's going, excuse me, figuring out what is, hearing the arguments and figuring out what was going on in Frazier. It looks like the defendant pled guilty to operating a motor vehicle while visibly impaired back in January of 2023, and that probation has been completed. The defendant is not on probation or parole at this time. And I have to determine whether Ms. Bush is a danger to the community that needs a high cash bond as the only means to make sure that that happens, or the presumptive release pending the terms of this hearing. I do believe that there is clear and convincing evidence that Mrs. Bush poses a danger to the community based on her actions or her alleged actions in this matter, as well as her past action, her past record. I don't believe that there are least restrictive means outside of a tether, outside of a cash bond in this matter. So bond is going to remain the same. Ms. Bush, your next date is
August 30th, Your Honor.
August 30th, 2024, before Judge Sabri. And that concludes the hearing.
Thank you, Judge. Judge, can I have 2 minutes,
Thank
please?
Yes, sir. The gentleman that's in Division 2, can you tell me your name? I think they got you on mute.
Okay, go ahead.
Yeah, I was having you, Michael, right?
All right, Mr. Wright, we're gonna do you next after when the attorney comes back, okay?
Hey, Sean, Mariah.
All right, sorry about that, Judge.
No problem. We got Mr. Wright here.
Right, Michael Wright.
Yes, sir. This is State of Michigan versus Michael Wright, case 23057433701. Today is the date set for the bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Lisa Coyle, appearing on behalf of the people, Your Honor.
Judge Wright, on behalf of Michael Wright, who's appearing via Zoom.
All right, thank you very much. And Mr. Wright, good morning. Today is the date set for the redetermination hearing. Mr. Reagan asked to bond.
Judge, this is a non-assaultive case. Mr. Wright just spent about 4 months in the OCJ, and to be honest, Your Honor, was homeless prior. There was a CAPIS issued by Judge Giles. There's been a few CAPISs, Judge, honestly. I'm not going to lie to the court. Mr. Wright was actually before this court back in January. You gave him a personal bond, but he was homeless. He now has a steady home in Inkster with his aunt, a place to live. So now there's no reason for him to not come to court, not be in court. So I'm respectfully asking the court to do whatever the court needs to do restrictively, but to grant a personal bond because, again, this is non-assaultive, does have a retail fraud history. But again, Judge, I think that whatever restrictions the court put on with the personal bond, now that he does have a stable residence, Judge, I would ask the court. So.
All right, thank you, Mr. Reagan. Ms. Coyle asked to bond.
Your Honor, you know this case involves him spray painting Wayne State buildings, and it's all caught on video. In this matter, it's about the Capias history. He was given originally in September of 23 a personal bond of $20,000. He then failed to appear 2 weeks later. He was arraigned on that bond on a bench warrant. A $30,000 cash surety was kept in place. You conducted the bond redetermination case on January 10th of 24. You gave him a $30,000 personal bond in which 16 days later, when he was supposed to appear for his preliminary exam, I'm sorry, he did fail to appear as well. So Judge Giles imposed again the $30,000 cash bond, and that's been remained in place. Your Honor, I'm asking for a nominal cash bond of $10,000, 10%, also a tether if he is shown not to appear in court. So I'm asking for, if you're going to give a personal at a tether, either way, I'm asking for some sort of cash to ensure his appearance.
You indicated that the defendant was in Oakland County Jail for the last 4 months. Well, what was that for? And Mr. Wright, don't speak. I don't want you to say anything that incriminates yourself. But Mr. Reagan, if you have the answer, I know you're on mute right now.
Oh, Judge, I'm sorry. I'm just sitting talking. I thought I was talking. I'm sorry. Judge, I think that's for a retail fraud case, Judge. I know he was transferred from Oakland County to the Wayne County Jail. It's my understanding, Judge.
Is he still under sentence, or was that awaited a case?
I believe that he's all done with Oakland County, Judge. And he was able to come over there for this case now. The deputies could verify as well. But that's my understanding, Judge.
Okay. Do you know if this was a misdemeanor in Oakland County?
I am not sure, Judge. I don't want to say. I can't tell you that.
Do you mind if I avoided your client
No,
just
I don't
asked
mind at
this
all.
information?
I don't mind at all.
All right, Mr. Wright, you can talk right now. I just want to get some clarifying information. What were you in Oakland County for?
Those were all misdemeanors. Most of them were retail fraud. One of them was trespassing. And I
Now,
just
sir,
wanna know
what city was that in?
for the retail frauds.
Yes, sir. Or do you know where the location that I guess that you took stuff from, or
Royal Oak, Royal Oak, Judge.
Royal Oak? Okay, that's what I needed. Hold tight.
That is not me under surveillance. I just wanted to go on record and say that that's not me. That's why I didn't show up, and I'm also homeless. I didn't know when and where the court was.
Okay, hold on. 1 second.
Mr. Wright, please be quiet. You're not helping right now. It's making it worse.
Okay.
But we're trying to figure this out. So just hold tight, okay? Mr. Wright, I have another question. Sir, did you plead guilty, or were you convicted of these crimes, or is this still pending?
Everything is time served.
Time served. Thank you. And sir, if I'm correct, you've been in custody since March of this year? or was that
April.
May? April, so in between. All right.
Yeah, I'm just here to right my wrongs.
Hold on, Mr. Wright.
Okay. So this is what I'm gonna do. This is the third CAFIAS, and I do believe that there is a flight risk associated with this matter due to the number of times that we've been here before. Understanding that the last couple of months, sir, you've spent in custody, and you have sounds like a stable place to stay now. I recognize that, and I do believe that we can get you back to court without a cash bond. So I'm gonna set this as a $10,000 personal bond with the GPS tether and house arrest wherever you're at. You're supposed to be staying at. I will allow you to receive medical treatment or to look for a job, anything of that nature. You can leave the house for. But while this is pending, you got to stay where you're staying at right now. Do you understand?
Yeah.
All right, Mr. Wright, you come back before this docket, it's gonna be the fourth time. And at that time, I look bad now, I'm gonna look crazy giving you a bond again on the fourth time. So understand that after this is a remand. You'll just be in custody until this is resolved. Do you understand?
Do I have to pay for the tether? Because I don't have any money.
You don't have to pay for the tether.
Okay.
All right, so your
Thank you,
next
Judge.
date is gonna be before Judge Giles on August 28th, 2024. August 28th, 2024, before Judge Giles. And you should be receiving some information as to that as you leave. All right, that concludes the hearing. See you, Mr. Wright.
Thank you, Judge.
All right, the gentleman at Division 1, Cam 4, can you unmute and tell me your name?
Here,
Yes, sir.
Elliot Shaker.
All right, this is State of Michigan versus Elliot Schaefer, case 24-045-84101. Today is the date set for a redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Celebrate on behalf of Mr. Schaefer, Your Honor, who's here for bond redetermination hearing.
All right, today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan Esteban.
Judge, this is a misdemeanor. It's a second offense. It's a misdemeanor, though, 1 year, Judge. My client's 24. He's employed every day, Judge. He works every day, Monday through Saturday, 5 a.m. to 9 p.m. High school graduate, lives in the city of Detroit, has 2 children. Now, saying all that, he's going to go stay with his mother, Judge. He has only 1 child with the complaining witness and was living on Claremont, but he's going to go stay with his mother. He informs us after we talked to Mr. Schaefer that these were lies, Judge. There were no injuries observed. No medics had to be called. It's my understanding that, the complainant says she doesn't even want to bring charge. That's my understanding. I'm not up to her, obviously, because it's the people of the state of Michigan who bring cases, but that's my take from what I understand. It's a DV case, Judge, misdemeanor. I think the court right now bond is 10,000, 10%, $1,000 with the GPS tether. Can go to work only and has to provide proof of the other work hours that he has. I'm asking that the 10,000, 10% bond, be reduced to 10,000 personal with whatever other conditions the court wanted to have. I just don't think that $1,000 should necessarily have to hold Mr. Schaefer in jail just because he's can't afford that at this time, Judge. So I'm asking the court to consider personal bond with whatever conditions the court wanted to put in place.
All right, Ms. Coyle has the bond.
Your Honor, the people are contending that bond is appropriate considering the danger to the complainant in this matter, Ms. Kiles. He has a 2021 attempt RNO, 2 counts, and a domestic violence out of the first district court. So I don't know who the victim on that matter was. This is charged as a DV second. So this is about an argument over the treatment of a child he has from another relationship. He allegedly smacked a 2-year-old on the back of the head. He then punched the complainant in the left side, stomach and arm, and then he strangled her, but she did not lose consciousness. I do note that in December of 23, there was a complainant refusal to prosecute, same victim, which he allegedly punched her in the face and stomach when she was pregnant with their child. She had at the time told officers that he had hit her in the past. She said that she was going to follow through with the PPO per the APA note, and she did not. So based on the fairly recent prior DV, as well as past history, I think he is a danger to Ms. Kiles, as well as I noticed that a CPS case has been opened. The complainant in this matter did call the police. This happened at the defendant's house. I'm asking for the bond to remain the same with the tether in place. Thank you.
And Judge, I don't know where the first district court is. Or is it, did you say first?
Monroe,
Monroe?
Michigan.
Okay, first district. Monroe. Okay.
he knows.
Yeah, that wasn't no DV either.
Hold on.
Mr. Elliott, I strongly advise you,
My bad.
remain silent.
Yes, sir.
Mr. Reagan, where does the defendant's mom stay?
Judge, his mother stays, did she stay in the city of Detroit, Mr. Schaefer, without saying an address?
It's on the reference side.
On the Redford side, so therefore not in the city, but close to the city, Judge. In Redford.
It's like across the street is Redford, across the street is Detroit, like right there.
I know what you're talking about. All right, I'm gonna set the bond at $10,000 personal. 1 second. I am gonna put a GPS tether on this matter. The defendant is to have no contact with the complaining witness, no contact with the Claremont address while this matter is pending. I don't know what's going on with the CPS case, but sir, you're to follow the rules laid forth by Protective Services as it relates to this matter as well.
They gonna contact me?
I believe so.
Thank you,
Sir,
Judge.
your next date in this matter is September 3rd, 2024. September 3rd, 2024, and that's going to be before Judge Garrett.
Your Honor,
Yes, Ms. Coyle.
there was a curfew imposed on that tether. Is that going to remain?
No, this is for monitoring purposes. I just want to make sure that he has no contact with the complainant.
Can I ask a question?
Hold on, Mr. Is it about the bond condition, Mr. Schaefer? Is it about the bond condition?
Yeah, the bond, the tether condition.
Yes, sir.
So that 61 Claremont address, that's my address. I'm the only one on the lease. It's Section 8. She was there, but she was only, like, her time was up. You know, you can stay 15 days.
Mr. Elliott,
Yeah.
while this matter is pending, you're to have no contact with the complaining witness. If she is at that address while this is, listen to me. If she is at that address, if she's physically at that address while this is pending, you cannot go back there, whether she's on the lease or not. So that's why I asked where you were staying. If you're staying with your grandma, that suffices to this. I have to do this to get you out of jail right now. So, you know, you can argue with me back and forth about it, but if you insist on going back there, then, you know, I got to do what I had to do.
No, I wasn't arguing with you, but I was just asking because I was talking to the people and they were saying to just ask you about it.
Yep, so I'm just kind of letting you know what's going on. So that's where we're at right now. Don't go back to that address while this is pending.
I'm not, I just got my mom's kid, it's closer to the job. Anyway.
Fair enough. That means, sounds like it's gonna work. All right, sir, your next date, September 3rd, before Judge Garrett.
September 3rd?
Yes, sir. Is that what I said, September 3rd? Let me double check. I don't want to give you the wrong date. Yep, September 3rd. All right, that concludes the hearing. Yep. All right, the gentleman on the Division 1 6th floor, can you tell me your name? You gotta have them unmute your device. Yes, sir. What's your name? Well, maybe not yet. We still can't hear you.
Say it again.
Kevin Littlejohn.
All right, thank you, Mr. Littlejohn. All right, this is State of Michigan versus Kevin Littlejohn, case 2405883-801. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Bill Ray on behalf of Mr. Littlejohn, who's here for bond determination hearing, Judge.
All right. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable in this matter. Mr. Reagan has the bond.
So that's why Mr. Littlejohn's bond is currently 50,000 cash, GPS, and alcohol tether. You know, my client's 47. I don't see any prior offenses, any prior drinking offenses. I could be wrong. I don't see any prior drinking offenses, Your Honor. I had a 1996 narcotic case. This allegedly occurred, Judge, in April 2023. The warrant was not signed until last week. It signed the warrant until last week, over 14 months later. You know, my client, Judge, is receiving Social Security disability. He actually just came out of a wheelchair just recently, Judge. He hasn't been able to drive a car at all, do anything recently. He's on 6 different medications. But, you know, Judge, I don't know of any prior DUI situations. Now, obviously, any case is unfortunate. This is not the division to try the case to talk about, you know, we know what the allegations are. We know what they are, Judge. But I'm saying in terms of bond, I think that the court could use a less intrusive measure than 50,000 cash a year later. I think that obviously no drinking, no driving, whatever other conditions the court wanted to put, but I would request a personal bond in this case, Judge.
All right, thank you, Mr. Reagan. Ms. Coyle has the bond.
Your Honor, this bond is appropriate considering have an OWI death and reckless driving causing death. Yes, this is one of the backlog warrants, my guess, based on it just being issued. This defendant was driving 78 miles an hour in a 35 zone when he hits a Jeep that was turning left in front of him. It results in the death of his front seat passenger. I believe it was his girlfriend. He was driving while his license was suspended. It's only charged with OWI and reckless because it was an FCJ as opposed to an FAC. He does have a prior criminal history, which is a 1996 delivery, which he did prison time for. And I also note that he had another possession of marijuana in 2003. I do note a 2004 aggravated domestic violence, a 2012 domestic violence, MDP under 200. In this case, the light was green for the Jeep. And what's most troubling is with toxicology results are a 0.182 blood alcohol level, positive for cocaine, positive for marijuana. The defendant's car 1 second prior to crash was traveling at 79 miles per hour, no braking. And 1/10 of a second prior to crash, he was still going 76 miles an hour as he was braking. Your Honor, this is a situation which he cannot, I don't care what his condition is, he got behind the wheel of a car drinking and had been doing cocaine as well as smoking marijuana. He was traveling at an excessive rate of speed and over twice the legal the limit in that area. It was a 35 mile an hour zone. He then crashes into a Jeep that had the green light and that he was traveling at excessive speed, Your Honor, and that it caused the death of somebody. This is a danger to the community, and that this is one of those things where people they make a choice whether to get behind the wheel of a car when they've been drinking. Not only was he drinking, he was ingesting cocaine and marijuana, and then he was traveling at an excessive speed. So these are choices, and that he can't make the right choice, that he can't do that at home if he's going to do that and stay there. But no, he chose to get into a motor vehicle and cause the death and potential death of others. He's a danger to the community. So I am asking, a tether's not going to keep him at home if he chooses to, and an alcohol tether, because he also had marijuana and cocaine in his system. So I'm asking for this bond to remain in place. He knows the system. He's been in the system since 1996. And so this is a case in which people make a conscious choice to get behind the wheel. This is no different than somebody firing a gun in the direction of somebody. It is a conscious choice. So I'm asking for all those bond conditions to remain in place, Your Honor.
And Judge, my only position, I do understand what Ms. Coyle is saying. I have a great deal of respect for Ms. Coyle, Judge, but when you talk about how serious this is, or allegedly is, it takes you 14, 15 months. You don't do anything. People don't do anything. You don't file a case. They don't, arrest my client. They don't lock them up. They don't do anything for 15 months. So, Judge, I think that this is all in perspective. Now, if we're at a trial, that's an excellent closing statement or even an opening statement. But we're just talking about bond here, Your Honor. And I'm just respectfully asking, at this point in the proceedings, he's innocent until proven guilty. There are a lot of things that have to come up and have to be brought out. And, and it's not the young lady who passed away. It's not her fault. I don't want to say that it wasn't charged sooner. I don't know why it wasn't, Judge. There could be a various number of reasons, but I'm not, trying to say it's anybody's fault. It just is what it is. And over the last 14 months, my client had no problems, no issues with drinking, driving, anything that we actually know about. So until he goes to trial and has a jury of his peers decide what happens, I just think bond purposes, you could tell him don't drive a car, no drugs, whatever other conditions you wanted to put on. And then a jury will decide, whether he is innocent or guilty of whatever he's charged with.
All right. I've had a chance to review the investigator's report as well as view the history involving Mr. Littlejohn. And I got to put this on the record. I believe one of these cases I was involved with, at least at some stage. I know, I had when I worked for Wayne County as a prosecutor, I was involved with Mr. Littlejohn on a domestic violence case. I don't know the outcome of that case, but I do know that we take testimony as it relates to that. What I have before me is a horrible, horrible situation. And I have a situation where someone died, someone related to Mr. Littlejohn, or at least associated with him, due to the actions potentially of Mr. Littlejohn. I have a toxicology screen that indicates that this person was not only have a high blood alcohol level of alcohol and marijuana, but also cocaine. Mr. Littlejohn's going to get his day in court. And if he is found guilty by a court of law, I hope every measure of justice is issued. As to this bond, I believe that we can keep the community safe without a cash bond. So I'm gonna amend this to $100,000 personal with a GPS tether and house arrest. Mr. Littlejohn, while this matter is pending, you can't leave the house, only for medical purposes only. Sir, you are not allowed to drive while this matter is pending as well. If you are caught behind the wheel of a motor vehicle, you are going to be remanded. Sir, your next date in this case is going to be September 5th, 2024, before Judge King. September 5th, before Judge King. That concludes the hearing.
Thank you, Judge.
Thank you.
The gentleman that's on Division 1, Camp 4, could you unmute and tell me your name?
Mark Anthony Kimbrough.
I heard Mark Anthony. What's the last name? Kimbrough?
Yes, sir.
All right, this is State of Michigan versus Mark Anthony Kimbrough, case 24058961001. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Celebrate on behalf of Kimbrough, Your Honor, who's here for bond redetermination.
All right, today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan has to bond.
Judge, as to bond, my client's 34, Judge. He does have some prior record dating back to when he was 18, Your Honor, to I believe 2009. He had a assault with intent to rob while armed, felony firearm case, Judge. He's employed now, Judge. He's 34 now. That was 2009, 2024, has 3 children. Works every day, Judge, at United Towing to support his family. This is a domestic situation, Judge, now. Obviously, reading the allegations in the investigator's report, very serious allegations. It talks about complaining being slapped, it talks about complaining being choked. Now, obviously, these are allegations, Judge, that Mr. Kimbrough is going to have to deal with when he comes to court. I think that obviously a no contact provision between he and Ms. Brown is definitely in order. I think the magistrate placed that in order. Now, the only thing I see is a $75,000 cash bond. I don't know if there was a tether added. I don't know if there was a curfew added. But I would note, Judge, I think that in domestic situations, unless you have so many previous convictions for that, I think that, Judge, the court could use no contact provision with a personal bond and whatever other restrictions the court wanted to allow him to go to work. He works to support his kids and come to court and make his court dates, Judge, and then deal with this case and face it head on. He has a court date in front of Judge King on the 30th of August. And so he understands that's where he's to be if the court allows him to be released on a personal bond with the other conditions the court wishes to add.
All right, thank you, Mr. Reagan. Ms. Coyle has to bond.
I'm going to use Mr. Reagan's reasoning in that it's not a domestic, but it's an assault with intent, armed robbery, felony firearm. So he put a gun to somebody to rob them, and he was convicted and did prison time for that. So he does have an assaultive record, and then he does prove to be assaultive. And here, Ms. Brown, the allegations are that he hit her in the face and the back with a closed fist. He slapped her, and he wouldn't let her get out of the house. He swung her by the hair to the floor. Officers did observe swelling to her head and face, bite marks on her back and her shoulder. Her injuries included a burst blood vessel in her eye from being strangled, a scratch on her hand, a bite mark on her left shoulder. She lost consciousness for 20 minutes. At the time, his father came in, saw her being injured, saw what happened. He told him to take her to the hospital, and which he did. And because she was 7 months pregnant with their child, and he took her to the Henry Ford Hospital and dropped her off, and then he left. So, Your Honor, he does prove to be a danger to the community as well as to Ms. Brown. that he obviously has no regard, he's complete disregard for her safety or her well-being or the well-being of the child that she was 7 months pregnant with, and he knew that, Your Honor. So for her safety to the community, the Magistrate White imposed the $75,000 cash surety bond, tether house arrest. I'm asking for that to remain in place, of course, with all the other no contact provisions.
All right, Mr. Kimbrough, I see that you had your hand up. Did you want to talk to your attorney? Tell him what you want to say, and then he'll put it on the record. I don't want you to say anything that would incriminate you right now. So I'm going to put you in the room. Hold tight.
Can you hear me now?
Yep, 1 second, Mr. Kimbrough, just join the breakout room when you get the prompt.
All right.
All right, Mr. Reagan, Mr. Kimbrough, you guys are back?
Yes, sir.
Mr.
Judge.
Reagan, anything else you wish to tell us?
Yeah, Judge, I just want to let you know that it's my understanding that Ms. Brown it's not 7 months pregnant. That's mine.
Okay.
I think I said 7 weeks. I'm sorry
I mean,
if I
that's what
said months. I
You
meant
said months,
weeks.
yeah. Said they found out
I'm
she.
sorry. My
7 weeks.
apologies. Sorry.
That's all.
That's
That's
why
all.
I said he knew about it, because 7 months he would obviously know about it.
Right. He said he didn't have any idea until they were at the doctor that she was pregnant at all. For 7 weeks.
No, that is very important information, so I appreciate you telling me.
Well, that's what she
so
said
this-
we knew, but
Yeah, this is where I'm at right now. I have a situation that's an assault, and I have an assault of history. The matter before involving a weapon, the matter in this situation, allegations suggest that there's a serious impairment of a bodily function, just as it's charged. I do believe that there is clear and convincing evidence that this person poses a threat to not only this complaining witness, but to the community at large. Bond and all conditions are going to stay the same in this matter. Mr. Kimbrough, sir, your next date is September 5th, 2000, strike that, August 30th, 2024, before Judge King, August 30th. And that concludes the hearing.
thank you.
Thank you, Judge.
Sir, can you tell me your name?
Sarah Williams.
State of Michigan versus Sanir Williams, case 24 058-95701. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And Your Honor, breaking on behalf of Mr. Sincere Williams, who is present for redetermination, Judge.
All right, today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan as the bond.
As the bond, Your Honor, Judge, I did talk to Mr. Williams' mom, who I think is present in court this morning, Your Honor. We had a long conversation about Mr. Williams. He's 20, Judge. I think there might be some developmentally delayed issues that Mr. Williams has, Judge. You know, he lives in the city of Detroit, Judge. Again, it's 20. You know, now the biggest thing, Judge, that I talked about is he's on probation right now. He's on probation for a unwanted touching of a minor. And I wanted to just be real specific about that because I think that's important in just talking with the mom and figuring out how this happened. It was at a skating rink. People were bumping into each other, and it's my understanding he bumped into this young lady. There was some, not a real level of intent. But again, he's developmentally delayed, has some other issues going, ended up being on probation for that. But I wanted to be forthright with the court about that probation, Judge. Now, this case we have before us, is a little different. It's a little different. But I think that, obviously these are allegations, and I did speak with his mom, Mr. Williams. I think, Judge, and we always ask ourselves, is he a capious history? Is he a danger? If he stays in the house, doesn't interact with anybody, I think that a GPS tethered house arrest, because he's not working right now. And you have to make better choices in situations. We're not talking about any situation where we're talking force. We're talking about just the lack of ability to do something based on the law, what the law says. The law says you can't do it. So I'm asking the court to grant a personal bond, with whatever conditions the court wishes to impose, Judge, in this particular case.
All right, thank you, Mr. Reagan. Ms. Coyle as the bond.
Your Honor, the people are requesting this bond to remain the same with tether house arrest and of course no contact with the complainant in this matter. She was 14 years old. He is on probation to Oakland County, not only for CSC 4, but also for resisting and obstructing and false report of terrorism. That was taken under HIDTA status. His probation began on May 2nd of this year and goes for 2 years. This occurred June 1st of this year. So within a month of being placed on HIDTA status for 3 felonies, he then did this, in which that the complainant and him knew each other for approximately 2 weeks. He allegedly performed intercourse and cunnilingus on the complainant, who he is 20 years old, and any 20-year-old young man knows that you can't have any sexual relations with somebody who's a minor because they can't consent. If anything, anybody knows, a young man, he knows that, but he did. And there's Instagram messaging between the two. She did identify him positively in a photo show. And based on his pending probation status, Your Honor, the fact that he knew that the complainant cannot consent based on her age, I'm asking for this court to keep this cash surety bond to place as well as the tether. Thank you.
One moment. Ma'am, come on up. Come to the podium. All right. Ma'am, could you state your name for the record? Ms. Fleming, are you related to the defendant in this case?
Yes, I'm
All right. Ms. Fleming, I understand that you had your hand up, you wanted to say something. I'm going to ask that you not talk about the case if there was anything that you wanted to let me know, as far as me setting these conditions of this bond, I'm gonna give you that opportunity now.
Since here is currently still in school, he goes to church every Sunday, he's videography. He does distance himself in houses. He's going through a lot of depression because he's being beat up and verbal abused by some of his siblings, which is out of the house now. But he's also on the teller. He's on the tracker teller, which tells where he goes during his probation, whatever what he's going through right now. I can't say anything that I know right now of the case, but he's not a flight risk if he's on a house teller. He can't go anywhere. He turned himself in. You know what I'm saying? To come in for questioning when he wasn't supposed to have police contact. So he's not going to run.
All right. Thank you very much, Ms. Fleming. That helps. All right, give me a moment. All right. I've had a chance to review the investigator's report as well as review the defendant's criminal history. I've got a couple of things working for Mr. Williams and a couple of things working against Mr. Williams as it relates to my ability to set a bond in this
Judge?
matter.
Okay, Mr. Reagan. Mr. Reagan wasn't on. I didn't want you to continue.
Oh, geez, I'm sorry. I'm sorry, Mr. Reagan. I didn't see you there.
No, I'm sorry.
All right. Mr. Reagan, strike that. Mr. Williams is currently on probation for a matter involving another sexually assaultive crime. While there are mitigating circumstances relayed by Mr. Williams' attorney as to why this is the fact of the matter is this is not the first crime involving an inappropriate sexual conduct that the defendant is involved with. Currently on probation under the supervision of Oakland County, where the defendant has a tether. I have allegations again of another inappropriate sexual conduct. This is a situation where the defendant, this allegedly took place at the defendant's house. And I don't believe any tether would have prevented that or could have prevented that because person was where he was supposed to be at the time of this case. So I do believe that I don't think a tether is gonna, stop the action from happening again. And I do believe that a cash bond is necessary to ensure the safety of the community. Bond is gonna remain cash. I am gonna lower it to $10,000 cash as surety, but they're still gonna include a GPS tether house arrest while this matter is pending. Mr. Williams, if you are to make that bond, no contact with the complaining witness, no contact with anybody under 13. Ms. Fleming, if you're able to make that bond, he has to stay somewhere where there are no children in the house. Is that understood? And I don't know what's going to happen in Oakland County. I don't know what's going to happen with this case, but sir, you're going to get your day in court. And the matter's going to resolve how it resolves. Next date is going to be August 30th, 2024 before Judge King.
Thank you, Judge. Judge, could I just say one last quick thing? The case in Oakland is a CSC4, so inappropriate touching. That could be a 70-year-old down to a 10-year-old. I mean, it's the inappropriate touching. It doesn't have an age on it, I don't believe, Judge, but I just wanted to make the court know. I understand this case is a very serious case with
Mr. Reagan, I got you, but this
Okay.
matter does involve an
Yes,
age.
it does.
That's why my order stands.
Thank you, Judge.
I don't know what happened with the CSC4 from the resistant and obstructed, but I do know what's alleged in this matter.
Yes,
So
sir.
that's why my order is what my order is.
Thank you, Judge.
That concludes the hearing.
Thank you.
Oh. Sir, can you tell me your name?
Malik, Mr. Cartwright.
Cartwright?
Yeah.
Hold tight, Mr. Cartwright. All right, this is State of Michigan versus Malik Cartwright, case 24058968001. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable in this matter. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
And on behalf of Mr. Cartwright, Judge, I'm here for a bond redetermination hearing.
All right, good morning, Mr. Cartwright. Today is the date set for the redetermination hearing. Mr. Reagan asked the bond.
The bond is $250,000 cash. My client, Judge, is 36 years of age. I don't know about prior history, Judge. I don't know of any prior history. I would note that, obviously this case is serious. My client says these are lies that the complaint is making up against him. This stuff did not actually happen. It looks like there was some type of money situation initially in the investigator's report. But again, Judge, my client denies any and all allegations. This allegedly occurred in June of this year, June 1st, wasn't signed until last week, Judge, almost 2 months later, for whatever reason, Your Honor. Obviously, Judge, we're asking for a reduction in bond. We think bond is excessive. So I'm asking the court to consider reducing the bond down, Judge, with whatever restrictions the court wishes to impose. But again, Mr. Cartwright says that these matters did not happen anywhere close to what is being alleged in this report.
All right, thank you, Mr. Reagan. Ms. Coyle?
I see in his lien that in January of 2017, the defendant was found to be legally incapacitated through Oakland County probate. And following in 2006, he had a home invasion, first UDAA. He was found not guilty by reason of insanity. He also had a 2012 great bodily harm, felony firearm. He was found guilty but mentally ill, which he received prison time. And he also had a 2011 aggravated assault. So he has an assaultive background with a lot of mental illness, Your Honor. So I will not say the complainant's name because he is a minor, but this, as you read, he met the defendant allegedly at a park near his home. The defendant had been watching the young men playing basketball with their shirts off. They all got creeped out, and they ended up putting on their shirts and leaving. The defendant, or the complainant in this matter, said, yeah, he took money from the defendant on 2 occasions. This is part of the grooming that people do in order to get close to minors. I'm not going to repeat the allegations, but he used a weapon to touch the complaint. The defendant used a weapon to touch the complainant. Allegedly, that knife was put to the neck of the complainant. He then sexually touched him and licked his cheek. Then also, I would note that the defendant came to the complainant's house. He was peering in through the kitchen window. The complainant told his father immediately that that was the man who assaulted him. The father followed the defendant to a local establishment. The police arrested him after, and the complainant made an on-scene identification of the defendant as being the person that assaulted him. The defendant also made a statement to the officers. He admitted to knowing the complainant and giving him money. He confirmed the story about coming to his house and inquiring about a phone. He admitted to having a knife around the complainant, but denied putting it to his neck. So what's frightening here is that the defendant knows where the complainant lives. He has a history of mental illness. The magistrate set a $250,000 cash surety tether house arrest. But to me, a tether is not a good thing, house arrest. This defendant is about 2 blocks away from the mother's address of the complainant, is about 2 blocks away from the defendant's house. The dad's house is about 4 blocks away from the defendant's house. And the park is about 3 blocks away from the defendant's house. So him being back in that environment not only places the complainant in danger, but also other young men and individuals in that community, because he was scoping out at a park. Based on his mental illness, based on his prior convictions, Your Honor, being assaultive, the great bodily harm, as well as the aggravated assault, based on what the allegations are in this, he is a danger to the community as well as to the complainant. So I'm asking for that bond to remain the same with all the tether conditions if he is able to make that bond. Of course, no contact with the complainant in this matter.
All right, had a chance to review the allegations as well as have a preview or somewhat of a review of the criminal history. And I do believe that there is clear and convincing evidence that the defendant poses a danger to the community at this point, based on not only the assaultive history, but there is these are allegations in which the defendant and the complainant know each other. There's at least one other witness who's indicated that this person knows where that complainant witness lives. And I don't believe that anything other than jail is appropriate at this time to protect the complainant witness. Bond is set at $250,000, which is intentionally unaffordable. With the GPS tether house arrest, if that person was to post bond or somebody was to post it on their behalf, I am going to keep the tether and house arrest conditions along with that bond I do believe it's appropriate, in case someone there does post that bond, no matter how high it is. Sir, your next date is going to be August 30th, 2024, before Judge King. August 30th, 2024, before Judge King. And that concludes this hearing.
Thank you.
Judge.
We only got like 30 left. All right, we're all set with Mr. Is that Cartwright? No. Yeah, we're all set with Mr. Cartwright. If you got somebody else, I'll hear him.
Hey, Judge, can I ask you a question?
Sir, I strongly suggest that you do not. If you want to talk to your attorney, I can put you in the room with Mr. Reagan so you guys can have a private conversation.
Yeah, I don't want to ask, what's the next court date, Mr. Reagan?
Oh, I'm sorry. It's August 30th.
And what is that? What process is that? No, what? Preliminary?
It's called a probable cause conference, which happens right before the preliminary examination. So it's a hearing where the attorney, what's that?
Can you put us in a breakout room real quick?
Sure. All right.
You want me to press join?
Yep. Hey, what's up?
Thank you, Judge. Well
All
said.
right.
Well said.
Thank you, Mr. Reagan. Sir, can you tell me your name?
Sherrod Dalton.
Thank you, sir.
You're welcome.
This is State of Michigan versus Sherrod Dalton, case 2405883401. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
John Reagan on behalf of Mr. Sherrod Dalton, who's appearing via Zoom for purposes of redetermination hearing.
All right, thank you very much. Mr. Reagan as to bond.
Judge, Mr. Dalton is 30 years of age, has no prior criminal history whatsoever. Judge, his family, I talked to his mom this morning, who's present, as well as his family, who's here, I believe in court today, Judge, and shed a lot of light on what's going on. Judge, this is a situation, Mr. Dalton and the complainant have a child together, and they've been doing some exchanges, I guess, at the police station. On this particular date, the complainant comes to Mr. Dalton's house, very irate, very, attacking Mr. Dalton. Your Honor, my client simply was trying to diffuse the situation, simply was trying to stop her from going off about their daughter. My client has 2 master's degrees, Judge. He employed every day. He works, doesn't have any history of any type of behavior like this, Judge. In the future, Judge, there will always be a third party facilitating this. Mr. Dalton and his family, Judge, took this young lady in. She didn't have a family. And unfortunately, he's in this situation. I don't think he's a threat. I think that the way in which the report was written up is exaggerated based on all the information that I've learned. I'm asking the court, Judge, for personal bond. Of course, my client works every day, has a good job, takes care of his daughter. And this is out of character, Judge, for him to even be, arrested, Judge. So I'm asking respectfully for the court to grant personal bond with whatever conditions the court wishes to impose.
All right, thank you. Ms. Coyle as to bond.
Well, I don't know how out of character is. There is a temporary PPO and lien shown that was served on April 15th of 24, the protected person being Ms. Flores. Then there was a PPO filed the day after this as well. That injunction was on the 24th. As the court can read, there was an argument regarding the child in common. Allegations or the defendant got in the complainant's face as she was sitting with the child on the lap. I think the child's about 4 years old. He allegedly put his hands around her neck and strangled her. And then she tried to leave and he was still strangling her with the child in her arms. She claims that the child bumped her head into the wall. The defendant grabbed the complainant, pushed her out the front door, and put the child in a bedroom. She then went back into the house, grabbed the child off the bed. He pushed her into a corner and strangled her again. Officers in the report show that observed severe bruising on her left side of her neck, which would be consistent to what the allegations are, a small cut on her right hand, redness on her knees and arms. The child had injuries, a small red mark on the left side of the forehead, red marks on the back near her shoulders. Apparently, they went to Trinity Hospital for treatment, and CPS has been notified. Yes, I agree, he has no criminal history, but there is obviously something going on prior to this date in which she got a PPO, a temporary PPO, and that was probably the injunction went into effect. The PPO was served, but it was temporary until he asked for a hearing. And what happened was, this is why the exchange was at a police station or wherever. But Your Honor, they do not get along. He has proven to put his hand here. We have allegations that he put his hands on her, and then we have circumstantial evidence that he in fact did so, that she had severe bruising around her neck area and redness on her arms and knees, consistent to the allegation. So for that reason, Your Honor, it shows that he is a danger to her. It is a volatile situation. I'd ask for all bond conditions to remain in effect.
All right, haven't had a chance to review the investigator's report. I would note that there's a PPO against the defendant in this matter, but it looks like the place of the offense is the defendant's house. I'm inclined to reduce this bond to $20,000 personal. I'm gonna remove the tether requirement. No contact with the complaining witness while this matter is proceeding. For the child in common, I'm gonna have a third party. There's got to be a third party. It has to be negotiated at a different time. But Mr. Dalton, you understand no contact means no contact. You can't talk to this person. You can't be around this person while this matter is pending. Do you understand?
Yes, I do.
All right. Next date is going to be August 29th, 2024, before Judge King. August 29th, 2024, before Judge King, 8:30.
Thank you, Judge.
I have a question.
All right,
Thank
that
you.
concludes the hearing.
Wait, is that it?
Sorry.
Was that it?
Yep, that's it.
So what, I have a question.
Well, sir, I'm gonna tell you this. If it's about the bond, I can answer it. If it's about this case, I'm gonna strongly suggest that you don't say anything. You're in a court right now. Anything you say can be used against you. But if it's about your bond conditions, I'll answer it.
Yeah, I was just trying to get an understanding about the bond conditions, sir. That was it.
Well, Judge, I
Okay.
can just tell him he's got a personal bond, no tether, absolutely no contact with her, must exchange your daughter through a third party. That's it, no contact.
Okay.
Understand? Okay,
Thank you, Your Honor. Thank you too.
okay.
All right, that concludes the hearing. Ma'am, can you tell me your name?
Alexis Sanders. Hey, Judge,
Yes,
is it possible I can talk to the attorney?
yes.
Thank you, Judge. Judge, is the back join? The move the mouse. See, I ain't gonna lie, that's the wrong way of doing it. I feel confident going to marry. I'm ready to do that. I'm ready to go. I got to
Sorry about that. I'm going talking. I've been muted. This is State of Michigan versus Alexis Sanders, case 24058946001. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Your Honor, Phil Reagan on behalf of Mr. Alexis Sanders, who's here for bond redetermination.
All right, Ms. Sanders, could you state your name for the record, please?
All
All right, thank you, Ms. Sanders. Today is the date set for redetermination hearing. Mr. Reagan as to bond.
Judge, I'm gonna try to be brief, Judge. My client is 22, Judge. Got a lot going on to be 22, though. Got a whole lot going on. On probation, Judge, for RNOs. It looks like she had on June 22nd, she got pled to 3 counts, so it makes her have 4, all on that date, Judge. Regardless, Judge, she has a newborn, 10-month-old that she's been away from, Judge. She was breastfeeding, that's not eating, because he's used to catching on to, I guess, her nipple and feeding that way. Hasn't been taking well to the other things, and she's afraid he's going to end up in the NIC unit if she doesn't get home. Her bond is not that much, Judge. It's only $500. With the tether, Judge, I would note that the complaint is her son's father, and I guess it's alleged she told her she had to pack her stuff and leave, and she kind of flipped out and broke some stuff up, Judge. That's the allegation. I'm not saying it's true, Ms. Sanders, at all, because I know it's more to it, and we talked about it, but I'm just talking about what the allegation is. It's a lot more to it, Judge, but obviously we're here. She takes care of her great-grandmother as well, Judge, as part of what she does, but I'm really concerned about the baby as well. But I think she understands that, no contact has got to be provision. She has another location she can stay. I just want to see her be able to go and deal with the baby. Now, whatever probation issues she may have, she's going to have to deal with that. That's not anything we can control. And she needs to learn, and I told her, you got to learn to control your anger. You have a child, you have a lot to lose, you're on probation. And we talked about that, Judge, and I think she understands that, this is not even a good look. She's away from her kid. So, to not do that, something she needs to work on. So I'm asking for a reduction in bond, Judge, to just a personal with no contact.
All right, thank you, Mr. Reagan. Ms. Coyle as to bond.
That's correct. She is on probation for 3 counts of R&O out of the 6th Circuit Court. She also has a 2019 conviction for under height status for interfering with the police investigation out of Westland District Court. She has an open warrant for assault and battery out of the Inkster District Court, which is 22nd District Court, which she has a bond of 150 cash surety. She also has an open warrant for OWI out of Romulus, that's 34th District Court. Her bond is $10,000, 10%. She has a failure to appear on that matter. It looks like she was intoxicated when this occurred. So they took her to the hospital to be cleared. She also has possible mental health issues. This is correct. This is a child in common. He did tell her to leave his home. She becomes outraged and irate. She bit him allegedly in the stomach, threw an amplifier at him and struck him in the back of the head. Then she threw broken glass at him and cut him on the wrist. She did a lot of damage. She damaged 4 TVs, glasses and necklaces. As a condition of her probation out of circuit court, she's supposed to have no assaultive behavior, no alcohol, and she was ordered to have a mental health evaluation. So I think that's what's going on here, Your Honor. I think she has not only a history of not showing up for court, she also has a history for being 22-year-old, very assaultive behavior. And with that mental health mixed with alcohol is a dangerous combination. So I'm asking for this bond to remain the same, as well as all conditions be kept in place.
All right, I've had a chance to review the investigator's report as well as hear a litany of criminal history. And Ms. Coyle, I do agree, there is a lot going on, including assaultive history, as well as failures to appear. However, I'm not going to keep this person in on a $500 bond. I'm going to amend this to 5,000 personal with a GPS tether while this matter is pending. One second, Mr. Reagan, where is the defendant staying at right now?
Let me see. She would stay, Judge, with her aunt and uncle. Is that correct?
Yes, sir.
With her aunt and uncle, Judge. That's where I have her. She has 4 kids total, but the newborn, Judge. But she's going to stay with her aunt and uncle, right?
All right. So I'm going to say 5,000 personal with the GPS tether, no contact with the complaining witness or that Fisher Street address while this matter is pending.
Judge, so I understand the court's concern. My thing, I wouldn't even mind keeping the cash, but the tether's the thing, Judge. It's Friday. She's going to probably take another 5 days to get the tether and be away from the 10-month-old. She understands, Judge, not to have any contact. I'm just concerned about the baby, Judge. I don't want to see the baby go back to the hospital.
Sympathetic to the condition that both the defendant and her child is in right now. But this is the least restrictive means that I can envision releasing this person with this history, with this capious history as well. So that tether is going to remain, but I am going to put a personal bond on this.
Thank you, Judge. Judge, can I talk to her in the breakout room briefly?
Yes.
Thank you.
Hey, Judge, thank you so much, Your Honor. It's something that made me really kind of think about this a little bit more when I was reading it, and I wanted to talk to Miss Sanders a little bit more. So I appreciate you giving me the opportunity to talk with her, Judge. And one of the things that she explained to me, and that she has a lot of bruising over her body where she was being dragged, obviously. But the bigger thing is that even Mr. Gregory Sanders has been calling up, trying to see how he can get her released, because they have a 10-month-old together, and the baby's not eating, and even though it's no contact, he's been calling up there trying to get her to be released. But he has her wallet, her phone, a lot of her stuff. She was living there, and I think that, it's other issues. And I when I read stuff, I kind of think, what makes her accused of throwing stuff at him or beating him up? But yeah, maybe it was, I think, a little bit of the other way around, Judge. And she actually, because of her temper toward the police, was the one that actually got taken. But now he's trying, I guess, to get her out because of their baby. And I know she has some other issues, Judge, but I would just ask the court respectfully again, and that's why I wanted to go back and talk to her a little more, to consider, not a tether, only if she won't go back near him if you tell her not to. But I think, the baby, he's even trying to get her out because he's concerned about the baby. So I'm asking the court to consider that, Judge. The court would just reconsider, Your Honor, because she's got to wait
Well,
about.
Judge, I can try calling the complainant and see if that's the case, if you want me to do that. But otherwise, she has a failure of not appearing. She's got a history of assaultive behavior and drinking. So I don't know how she's breastfeeding when she was intoxicated.
I'm sorry. I'm sorry.
But anyhow, I can call the complainant.
Stop, please. 1 second. I'm sorry. You got to get out of the courtroom. Officer Hamilton, you got to get this person out of the courtroom right now. Which case were you on? We'll bring you back in when your case comes up, but. It's either going to be you or I'm going to kick everybody out.
Yeah.
I'm sorry, I have to stop court on an unrelated matter.
Totally get it. Would you like me to call him? Oh, shoot.
Hold on 1 second, Ms. Coyle.
Sorry about that. I had to stop on an unrelated matter. Ms. Coyle, if you can call the complainant.
Thank you, Judge.
We greatly appreciate it.
Thank you, Your Honor.
I'll
Would you
recall
like
this
me to
case.
call?
Yep.
Please.
Yes,
You want to
please.
do it now? You want me to do it now if I look up his number and see if I can find it and try to get a hold of him?
Please, Ms.
Well, how
Coyle.
about this? My order is going to stand. Ms. Coyle, if you give me that information before, at some point, when you get some chime, then I'll change the order and submit it to the jail.
Okay.
I have his
Okay.
number right here, Ms. Coyle, too.
Well,
Yeah, but
why
we
don't you
can't-
text it
we
to me,
can't do
please?
this
Please
right
don't
now,
put it on
Mr.
YouTube.
Yeah.
Just text it to me.
And we can't do it right now because I still got a lot of cases that I got to get through, and I need Ms. Coyle, and I need you.
I understand, Judge. I understand.
So, I will tell you this, Ms. Sanders, if that information checks out, then I'm going to take the tether requirement out. I'm putting the tether requirement on now, but if I get that information, I will change it and you'll be released. You got to resolve these warrants that are out here.
Judge, I've been trying to do that. I don't have a car. I have the money to do whatever you asked me to do. I promise you I do. The incident that happened in Inkster, that happened years ago when my first baby daddy passed away. He passed away last year. And I've been trying to get that off my record.
So, Ms. Sanders,
hold on.
I'm going to stop you right here. When you tell me I'm trying to do this and I don't have a car, and then you tell me that that's years ago, already years ago, I'm going to leave it at that, because we're trying to get you out right now. And I don't want you to say anything to mitigate this. I'm just telling you what you have to do.
And I will do it. I will do anything you ask me to do. I promise you. As soon
All
as I
right.
get out of here, I have the money to
So-
do.
So
I got the
right
money.
now, the bond, stop.
Oh,
Right now, the bond stands at 5,000 personal with the GPS tether. If I get word from Ms. Coyle that the complaining witness wants to make sure that you're out and this feels comfortable with this no contact, then I'm gonna remove the tether. That's gonna happen at some point today.
Okay,
So, if I get that information, we'll send that information down to the jail. You're gonna be released.
okay,
I'm gonna give you the next date right now, and then we're gonna keep it moving, okay?
okay. Thanks.
All
Judge.
right. Thank Mr. Reagan
Thanks, Mr. Reagan.
and Ms. Coyle, because, the understanding is, we don't want to keep you in if we don't have to.
right.
And if that's the case, then I'll listen. So let's see, Ms. Sanders, your next date is August 29th before Judge King at 8:30. And then when I get that information, or if I get that information, I'll send the mid down to the jail so you can be released.
Thank you.
You're welcome. That concludes the hearing.
All right. Thank you, Your Honor. Thank you, Ms. Coyle.
No problem.
All right, ma'am, can you tell me your name?
Aisha Boykins.
All right, keep bringing. All right, this is State of Michigan versus Taisha Boykins, case 24058958001. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
We'll break it on behalf of Ms. Boykin, Your Honor, who's here for bond redetermination hearing.
All right, today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan as the bond.
Judge, so Ms. Boykin, Judge, is 34. I don't know of any criminal history. I could be wrong, Judge. Sometimes I'm wrong. I know she's on SSI. I know she has 5 children. Her mom is here, Judge. She came today. We talked a little bit, Judge, but what I really did, I really went through this report, Judge, and it made a lot of sense based on the information that I got. She's charged with, I believe, shooting somebody based on the fact they found a firearm in her purse. I don't know if there was a lot of witnesses that actually do this outside of Mr. Williams, who they questioned and released, in which said that he found this gun a few days ago, but somehow this gun ended up in Ms. Boykin's purse. Now, one of the things also that was interesting, the officer said that a witness said that they heard my client say, hey, did you get rid of this gun? No. Well, it makes no sense, Judge, for her to say something like that when the gun is actually in her purse. So I'm thinking maybe that's not really true in that statement, but I think that they may be looking at the wrong person for this crime, Judge, actually, based on the fact that initially they were all riding in the car. And I think Mr. Williams got upset because he accused my client of talking or being really friendly with the other men in the car, including Mr. Roberson. And then Mr. Roberson ends up getting shot. My client, obviously denies any of this, although it says that she makes a statement, Judge, which I don't know how credible that is. I know my client does suffer from some mental issues. She's on Depakote. She takes some different medications. But it's very interesting how this is written, Judge, and how this ended up. She ended up getting charged with it. I think there's a lot of things that are going to come out later, and I think that Mr. Williams plays a big key in this, in which we need to find out a little bit more. But I'm asking, Judge, obviously, You know, she has family support. Her mom's here to make sure, you know, that she comes to court. No contact with this person. Again, no priors. That's to me is important, Judge. She does have seizures from time to time, but again, she has family support. So I'm asking for a reduction in her bond, Your Honor, based on, you know, when I went through this really thoroughly and kind of asked some more questions. So I'm asking for a reduction, Judge.
All right, thank you, Mr. Reagan. Ms. Coyle Esteban.
Your Honor, I do see a record for a 2017 assault and battery, a 2017 attempted domestic violence, a 2017 retail fraud, and a 2020 disorderly. The allegations are that the defendant shot the complainant in the face 2 times and twice in the buttocks. A gun was recovered from her purse, and a witness stated she said he was beating on me and my sister, so I shot him. The allegations further are that complainant was in the front passenger seat. She was in the rear seat behind him. She swung on him basically to wake him up. I think he had been drinking. All occupants exit the car. Ms. Lewis calls the police because of this. The complainant was sitting in the front seat, and then the defendant walked up allegedly to the driver's door and shot the defendant or the complainant twice. Then the complainant crawls out of the car, and when he's crawling out on the ground, the defendant walked to the passenger side and shot 2 more times. So, as the APA note was, the complainant in this matter is not expected to survive. That note is dated August 21st. So this is probably going to be eventually, unfortunately, possibly be a murder 1, premeditated murder. This physical evidence show the police found a shell casing in the street next to the driver's door. Also, 1 underneath the car. I'm sorry, 2 shell casings underneath the car. A shell casing on the passenger side of the vehicle, and another one, the passenger side front window rubber trim. So that is consistent with what it shows. There is also some sort of video which shows a woman in a white dress, and that's what allegedly the defendant was wearing. Also, the defendant gave inconsistent stories about what occurred, and that she puts herself as the shooter. At this point, Your Honor, we're not looking at whether this is an issue of guilt or innocence, but whether she's a danger to the community. And Your Honor, based on whatever the allegations here and the physical evidence have been spelled out in the IR at this point, she is a danger to the community. I think a $200,000 cash surety is actually low in this matter, because this shows premeditation, that she deliberated, walked over to the other side of the car, and physical evidence as written corroborates that. So I'm asking for that bond at least to remain the same based on this, with the tether provisions as well.
Judge, and I would say just briefly, Judge, no one saw my client shoot anybody, especially even the driver of the vehicle, Miss Lewis, who gets out of the car and walks up the block, never says she sees my client. There's no video of my client shooting anyone because my client didn't. I think the police need to really look at Mr. Williams, who had found this gun a few days ago, Judge, who was actually questioned and released. My client had no reason to shoot Mr. Roberson. That they were, you know, on good terms. Now, you know, it's a lot more to this, Judge. And again, there's the only physical evidence is the police saying they found the gun in her purse. Now, I understand the inconsistent story because my client is scared to really kind of say, or at the time to say what really happened for fear of some things. But at the end of the day, Judge, there is no video or no one is going to actually say that my client actually did this. And I feel bad for her because she's charged with it. And maybe if she would say some certain things, she may not be. But, you know, we're here, Judge. And, you know, she doesn't have any history of things like this. And I do know the criminal history, the misdemeanors. I didn't have that because I don't have a lien system, Judge. But, you know, I don't think she's a danger, Judge. And I say that with the information that I know after hearing it, reading more into what really the investigator's report said and looking at the alleged evidence. I don't know how well this will stick, Judge, once a lot of things come out.
All right, give me a second.
Judge, while you're looking, because I talked to my client in a breakout room briefly.
Thanks, Joanne.
I think I put one.
On another laptop.
Moving around to the mouse. Bring them out.
Thank you.
I'm waiting for Ms. Boykins to come out the room. Whoa. Do we have Ms. Boykins back?
Oh.
Yeah.
I'm sorry.
All right.
They thought it was over.
Yep, sorry about that. Mr. Reagan, is there anything further?
We just had a come to Jesus moment. We just talked about, I don't even know if it's too late at this point. I mean, I always talk about not talking to law enforcement sometimes, but I think this is a time where she really needs to talk. She really should tell what happened. I mean, I don't know at what point we're at, but I told her when she gets her next lawyer, you need to talk to your lawyer and really, tell what happened.
There's a lot going on this matter, and maybe we don't know anywhere close to what's actually happened. I've had a chance to read this investigator's report, and I had to read it 3 times to make sure I understood what was going on. The one thing is clear is that there is a person, shot at least 4 times, twice in the face and then twice in the back. There's one witness who identifies the defendant as the shooter, shooting through the car, and then after the complainant gets out of the car. I believe that there is clear and convincing evidence that there is a danger to the community that has been established by this person, and bond is going to remain the same at this time. Ms. Boykins, if you have additional information to give to your attorney, make sure that you do that. You are not guilty until proven so, or found guilty or plead guilty. So you have the presumption of innocence right now. This bond is set for the reason set forth, but all indications and everything you can to resolve this matter or provide a defense in this matter, you have to your disposal. So I'll leave it at that.
Thank you, Judge.
Ms. Boykins, your next date is August 29th, 2024, before Judge King.
Okay, no problem. Thank you.
All right, that concludes the hearing.
Yeah.
You have a blessed day.
Ma'am, can you tell me your name?
One of us was.
This is State of Michigan versus Juana Vasquez, case 240589491. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Reagan on behalf of Ms. Vasquez, Your Honor, who's on the determination hearing.
All right, thank you. Today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan has to bond.
That's the bond. My client's 29. To my knowledge, no prior criminal history. She has 2 daughters. Judge, she lives in the city of Detroit. Judge, this house is a house in which my client lives. She pays rent there every month. It's not, they're saying home invasion third, but this is where she lives. This is where her daughter receives disability too. But my client also, Judge, goes to Teen Wellness, and she's needs to get to Teen Wellness in about a week to get her meds. She can go to her cousin's house at the court while the case is pending till it can be figured out. Stay with her cousin. $750, Judge, is not a lot of money. But she understands, and we talked about no contact. So no contact. So I'm asking for $7,500 personal with the no contact provision so that she can fight this case. I don't think a tether or house arrest is necessary in this, Judge. I think that she understands no contact and will abide by whatever rules, whatever conditions the court sets, Your Honor.
All right, Ms. Coyle has to bond.
Your Honor, she has right now a pending entering without owner's permissions, MDP 200 to 1,000, right now pending in this court. She has not been arraigned on that yet. That occurred on April 18th of 24. She has an active PPO for stalking. The protected person is Alicia Mendoza Castillo. It was served in May of 24. She has also a 2018 retail fraud, 2018 failure to report an accident, driver license suspended, 2018 OWI, 2018 larceny under 200, 2018 possession of a controlled substance. This is her father. She broke into the home without his permission. That's why it's charged the way it is. She then broke a TV, and there was an active PPO, and she knew she wasn't supposed to be there. The officers took her to DRH because of her, when they got in the house, she was there with whippets and she was crying. So she was supposedly under the influence. She said that she was drunk and blacked out, and she didn't know she damaged the TV. So, Your Honor, this is an ongoing escalating incident. The parents don't want her there. There's a PPO in place. She has obviously some substance abuse issues. I'm asking for the bond to remain in place, of course, with all the other conditions involved.
Judge, I think there might be some more mental health issues as well, and I understand. These are parents, but she says she pays rent there now. If they don't want her there, she probably needs to go. But I don't know about.
Well, we know that's been the case since April.
But see, Judge, and that's what I don't understand. How is it that we're here and in August, and she has a case from April that she's never been arraigned on in our court?
I'm not talking about the case. I'm talking about the PPO that's been in place since April with Miss Mendoza Castillo, the grandma.
I don't know about. I'm sorry, Judge.
It's in the investigator's report.
I'm saying this is my first time hearing about the PPO. Now, this is a place, Judge, where it's my understanding my client was paying rent, and living, Judge, on and this is very.
I mean, this is a dad and a grandma. I mean, this is all family stuff.
Right. And it's my understanding she was living, paying rent there, Judge, and was going there. So since April,
let's cut to the chase.
Okay.
Who is this cousin? Where does this cousin live?
The cousin, Judge. Where did you say?
I was gonna see if I could speak with you real quick.
Okay, put you in a room.
Thank you, Judge. Go to the room.
Judge,
Yes,
on an unrelated matter, we had another man, Davion Henderson Yarber, on the docket.
Yarborough.
Henderson Yarber.
Yes,
What happened to him?
we don't have it up today. I got it on the docket.
You don't?
I said I have it on the docket.
Right, it's a man. Oh, okay. I didn't know if we missed him.
Oh, no, we still got a lot of cases.
Yeah, I know. Okay, just
Yeah.
asking. Okay,
Oh, one
Thank
second. Is
you.
is he not supposed to come before us? I'm trying to figure out what's going on.
No, he's on the,
Yeah, he's on the jailer's list. Was that who posted? Who posted? Oh, we did one
Did
person.
Tucker post?
Yes.
Okay, thank you.
And we're trying to figure out, Ms. Bob's, she's not on the jailer list, but she had a $1,000 or $10,000, 10%.
She probably posted too.
I'll check again, because that was.
Or she had another case down here.
You know, I'm still seeing. That's one thing.
All right, you're back, Ms. Vasquez. Mr. Reagan, is there anything you wish else to tell me?
Just briefly, Your Honor, Judge, it doesn't ever seem to amaze me how wise you are. You said a key word in this whole thing, Judge. You said family. And that's, just talking to Ms. Vasquez, like you said, the PPO is in April, but yet, grandma said, oh, I'm gonna lift it. You're gonna still pay me rent, and my client thought PPO's lifted, everything's fine because it's family. And family goes back and forth. Now her mom and brother have told her that they're going to take her when she's released to go to inpatient treatment. That's what I think she needs. Ms. Coyle brought up some very good points about the substance abuse situations, Judge. I think that's an issue here. And I just talked to Ms. Vasquez and we were straight up about it. And I think that's important. So, we talked about no contact with grandma, even though whatever grandma says, the PPO is in place. It hasn't been lifted. So you can't have any contact with it. She understands that. She needs to go get help for her daughter's sake. And we talked about that. And that's important. So she's going to go to inpatient, not outpatient, inpatient, to try to deal with whatever issue she had. I think that's important, Your Honor. So I'm asking the court to reduce the bond and personal because they don't have the money.
So my question is, who is this cousin and where else would she be staying if I've reduced the bond?
You did ask that question, didn't you, Judge? Where's the cousin and where are you going to be staying, Mr. Blackwell? We talked about so many other things. Where will you be staying if the judge is inclined to reduce the bond?
We're going to be going to the inpatient. It's right there on 70. It's called Sacred Heart, I believe it is.
Okay.
That's where my mother and my brother had called for me yesterday to get me into. He goes by Sacred Heart.
So Judge, so that's the new thing we discussed. I have my notes to talk about the cousin. You have a cousin, correct?
Yes.
Where is that cousin? Don't say the numbers, but where does that cousin stay? What street?
Couple like over by in Lincoln Park. It's like a block from like Myers.
Okay, so now can you go and stay with that cousin?
Yeah, but I do want to go to the inpatient.
I understand what you want, but can you go stay with that cousin?
Yeah.
Okay, so that's what the judge wants to know. Because if the judge is inclined to possibly maybe reduce you with he may want you to go to that location. Okay, that's why you asked that question. Can't go near grandma's house. Can't go near. Yeah, all that. Can't do that.
All right, 1 second. All right, I'm gonna set this bond at $750,000 personal with a GPS tether house arrest. I will allow an exception for Ms. Vasquez to attend inpatient treatment if something is set up. Ms. Vasquez, your next date is August 29th, 2024, before Judge Giles. Ma'am, let me make this clear that whatever medical treatment that you're gonna get cannot interfere with these court dates. So you need to make arrangements to make these court dates while they are pending. Do you understand?
Yeah, I understand.
All right, that concludes the hearing.
Thank you very much.
You're welcome.
Thank you, Judge.
750,000. No, 7,500 personal. Yeah. Ma'am, can you tell me your name?
Miss Bradshaw.
All right, thank you, Ms. Bradshaw. This is State of Michigan versus Tanya Bradshaw, case 24058963001. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
So Reagan, on behalf of Mr. Bradshaw, Your Honor, who's here for bond redetermination.
All right, today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan asked to bond.
Can you give me 10 seconds, Judge? I apologize, of course.
Sure.
It's even worse than the bomb. It's worse than the bomb.
But I didn't do it, so I came back. Because I'm briefly from South Carolina. In South Carolina, in Holland, we got the first one to the car like it's snow. I didn't have no out in the I'm up here to go. We go through there. One touch my face, like a little breeze of milk or something.
Oh, excuse me.
Somebody thought it was. They will be my, my teacher or whatever it says.
All right, I'm sorry, Judge. I apologize. Okay. One of the things I wanted to look at, anytime there's a domestic relationship, I try to get a better understanding. Her bond is 100,000 cash. You know, my client works at America Park, but she is on probation for embezzlement. She's on probation for embezzlement, not assault. And now, you know, when I read the investigator's report, Judge, it kind of reads a little I don't know the word, Judge, but it's a little disturbing. But now I would note that there have been four prior cases of alleged DV. Mr. Latham has refused to prosecute in the past. You know, I think it says here he wants to go forward. I know that they, have been on and off. What I'm asking the court to do obviously no contact, GPS tether, house arrest, you know. I'm asking for a reduction, Judge, too personal, but I'm asking for those conditions. I think no contact, and she needs to sit in the house. She can't go to Comerica. Season's almost done. She can't work anymore. She's got to sit in the house. And I'm saying this, Judge, because I don't want to be a trial fact here. I don't want to determine, what I'm reading in the hearsay document to take it as true, because it's always a lot more to it. But yeah, based on what I'm reading, I think staying at home is important. So I'm asking for a reduction with the condition of house arrest, GPS tether, maybe 2 tests, GPS tether, and she can't go out the house from her. So I'm asking for a reduction to a personal bond.
All right, thank you, Mr. Reagan. Ms. Coyle has the bond.
As to her criminal history, I do see a 2017 larceny in a building, and she is on probation, as Mr. Reagan said, the Sixth Circuit for embezzlement. On her lien, there were several identification numbers, California, Washington, Michigan, Ohio, which listed, it's so long to even list how many cases that there were based out of all these states, and including bail jumping. But with that in mind, Your Honor, this standing on itself is extremely disturbing in the sense that, and shows that she's not only a danger to the complaint in this matter, but to the community, in that she's so nonchalant about her actions. Officers did observe and smell the odor of gas. They also noted the cut to the complainant's eye. They observed the video in which the defendant had a gas can in her hand, flashing the gas on the car. The video also shows the defendant punching the complainant, shows her setting the car on fire with him in it. The defendant's statement that she admits to grabbing the gas can, to pouring the gas and lighting it. And when asked, she said, he probably would have died. He would have burned up, but I wouldn't let him die. I would have tried to put him out. That's frightening. I also noted in the investigator's report, there were DV complaints between the two of them from 2021, where the complainant was the victim and he refused to prosecute. And in 2023 and 24, there were 3 reports that the complainant is the defendant, but she then didn't follow through. So this is a very volatile situation. This is a situation which could have caused more than just damage to property, as well as she's pouring gas on his body, soaking his clothes and assaulting him with, she had, if I recall, keys in her hand when she struck him. Your Honor, the evidence is very strong. It's on video. There's evidence of the burning. She also confessed to this. She is a danger to the complainant and to the community, and also a potential flight risk. And she is on probation, and for 3 years. So she knows she's not supposed to be doing anything assaultive. So based on all that, Your Honor, I think the bond is appropriate considering the nature of the offense, as well as all the other bond conditions.
I agree. The allegations in this matter are beyond disturbing. But I believe that, this creates a situation where I believe that there is clear and convincing evidence that this person is a danger to the community. Not only pouring gasoline on, the piece of property, but on someone, and then, igniting, shows me, and these are allegations. I don't know exactly what happened. But I don't trust this person right now. And I don't believe that anything outside of a cash bond can be used to make sure that this doesn't happen while this matter is pending. So bond is going to remain the same.
Thank you.
Ms. Bradshaw, your next date is
August 30th.
August 30th. Yep. At 8:30 before Judge King.
The court considered 10%. Judge, they were going together. I mean, they were in a relationship together.
I hope that's, I'm not going to say it. No, this concludes this hearing. I'm not giving the 10% provision.
10%, Judge?
No. That concludes the hearing.
Good morning, Your Honor.
Good morning.
Unless you got anything for us, Your Honor, that concludes the list, I think.
I have a Davion Henderson Yarber. And then I also have Demetria Tucker. Oh, Tucker bonded out, I'm sorry. And a Bosley.
Bosley.
Bosley and Henderson Yarber.
What about Mark Kimbrough? Your Honor, did we do him?
We did Kimbrough.
We did Kimbrough.
What's that?
Just have the two left.
Positive, Your Honor.
Who's COVID?
Henderson Yarborough.
Oh, okay. Do you want to do this, Mr. Reagan, without your client's presence, or you want to put us over to Monday? And if he's still testing, then I'll continue on.
Judge, I like to do it now. I mean, it's Friday. I would like to try to do it if I can.
You'll have to waive his presence, and we can't do it if he's testing positive.
I will waive, Judge, because I think I want to, that's the purpose of this hearing, to try to reduce bond. And if I can, I want to try.
No, I got you. Let me call it. This is State of Michigan versus Davion Henderson Yarber, case 24058965001. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Celebrating on behalf of Mr. Davion Henderson Yarborough, Your Honor. I'd waive his presence for purposes of this hearing, Your Honor.
All right, today is the date set for the bond redetermination hearing. Bond is set intentionally unaffordable. Mr. Yarborough Henderson is unavailable right now due to a medical situation. Mr. Reagan, do you wish to waive the defendant's presence?
Yes, Your Honor.
All right, as to bond.
Yes, the bond, Judge. My client's 32, no prior criminal history to my knowledge, no other pending cases. This allegedly happened at a casino here in Detroit. His bond is $10,000 cash, surety, GPS, tethered curfew, house arrest, go to work only, no contact with any casino. My client, Judge, actually works at a beauty and braid shop. He cleans up Monday through Friday, 8 to 6, has 3 children. It's alleged that he was at the casino, Judge, and he pushed someone, took her purse. She got all her belongings back. Nothing was missing. I don't think, Judge, if the court were to impose a no contact with casinos, I think that would be sufficient. I don't think a cash bond is necessary in this case. I'd ask for reduction to 10,000 personal, whatever conditions the court wishes to impose. Again, no priors, no pending, nothing to my knowledge. She is employed with children.
All right, Miss Coyle as to bond.
Yes, he admitted to being at the Motor City Casino. He was watching her, saw her get up, and decided to take her purse. He admitted that he ran up, grabbed her purse. Her left leg was injured as a result. This was all on video, of course. It's in a casino. I do note that the complainant, he was watching her. He admitted he told the police that she owed him money for dope. Well, the complainant in this matter is 79 years old. Okay, so what he was doing was targeting an elderly person gambling in the casino, watching her, grabbed her purse, snatched her purse, and as a result, her leg was injured. Your Honor, he is a threat to the community. He shouldn't. This is assaultive. That's why he's charged with that. And so I'm asking for that bond to remain in place.
Does the defendant have any criminal history?
I see, only thing I found, saw nothing in Michigan, but I did see a failure to appear out of Mayfield, Kentucky from January 30th of 2019. But it did not say what the offense was for. Because sometimes the out-of-state liens are ambiguous at best.
Okay. I got him at a Stansberry address. I'm gonna amend the bond to $10,000 personal with a GPS tether house arrest. If the defendant is able to, is able to tether at that Stansberry address, he's not allowed to leave the house, only for medical reasons only. Mr. Henderson's next date is August 30th, but we'll get that information and provide it to the jail.
Sure.
All right, and you guys say you don't have Laquita Bosley. I don't see it on your inmate search.
No, sir.
So we're just gonna continue Ms. Bosley.
Do you want me to call the complainant on that other case, Mr. Foss? Sanders.
Yep, if you
You
could,
want-
Ms. Coyle.
You
Yep,
want
and if I,
me to do it while
Um,
we're on and take a moment, or
yeah,
we can
just
do it on
while
the
we're
record?
because I don't have
All
any,
right.
I don't have
All
any
right.
other
Give me a-
defendants at this point, so.
All right,
yeah.
give me a moment then. All right, thanks.
All right,
Thank you, Coyle.
all right, thank you, Wayne County.
No problem. Have a great weekend.
You too.
You go to work, no?
No.
Okay, I just looked at that.
Yeah.
Good.